Good morning, everyone. Welcome to Financial Friday. This is the What Now movement Facebook group. I am Elsa W. Smith, your your estate planning, Maryland estate planning attorney. Today is Financial Friday, and we're going to talk about the intersection of finances and estate planning. I'm the owner of the law offices of Elsa W. Smith. I'm licensed in Maryland and DC. Our firm's mission is to protect you, your family, and your business. My business model is actually has two pillars. One is education, and the other is empowerment. So, how do we, specifically me as an estate planner, how do I help people? Well, one of the ways is that I give so much free content towards that education piece. If you follow me on Facebook, if you follow me on Instagram, if you follow me on LinkedIn, on Twitter, and of course my YouTube channel, all at Elsa W. Smith Law, you're going to get so much free content to help protect you, your family, and your business. And I do that because anyone that has worked with me for any period of time knows how passionate I am about the estate planning work that I do and the families and the individuals that I am helping to just change their life. I can't tell you how many times, that a family or an individual contacts me after the estate planning process is done, and they communicate that they have such a relief, knowing that their affairs are in order. So you might have also seen, in addition to all that free stuff that I told you about, the YouTube channel and all the other social media platforms that I'm on, where you can get great content. There's also currently a Facebook ad running for a webinar that I am doing. It's the Estate Planning Women's Edition, How to Go from Overwhelm to Empowerment. This particular webinar is specifically targeting women because historically, traditionally, I find that we leave so much of our assets, our security, to the male figures in our life, whether it's a father, whether it's a spouse. So this webinar, the purpose of the webinar is to teach women to just take control of their lives, their families, and their businesses, all through estate planning. So you may ask, I should say, what do finances have to do with estate planning? This is Financial Friday here on the What Now movement. And my answer is everything. Finances have everything to do with estate planning. I want to share some facts with you. According to a 2020 study done by caring.com, among 35 to 54-year-olds, in 2019, only 37% of the people that were surveyed said they had any kind of estate planning done, any kind of estate planning documents. Only 37%. And in 2020, that number dropped to a little over 27%. And that's just in the 35 to 54 age range. For my 55 and older group, in 2019, only 60% said that they had any kind of estate planning done. In 2020, the figure dropped to 48%. So in both categories, in both age ranges, we're seeing a downward trend, I should say. And here's one more fact. And this one I found the most alarming. According to Black Enterprise magazine, nearly 70% of African Americans have no will or estate plan in place. Let that sink in for a second. So what is at stake? What are we talking about? It's the ability to transfer generational wealth. We're falling short and we need to do better. So the question I have for you watching me right now, and I see more and more of you chiming in, are you part of that 70%? Simple question. You either do have your affairs in order or you don't. And my objective today is to share some tools that hopefully are going to educate you a bit more and just finally get you off the fence and moving in the direction of creating your estate plan. Specifically, today's topic is 7 estate planning mistakes that block you from financial success. Again, 7 estate planning mistakes that block you from financial success. So here we go. Mistake number 1, I hope you're taking notes, is not understanding how your assets will pass once you die. A will, if you have one, is not enough. You need to, check your beneficiary designations in your life insurance policies, in your retirement plans, your 401ks, my government people, your TSPs. You need to make sure that your beneficiary designations are up to date. These types of accounts do not go through the court system. A horror story, and some of you that are watching may have heard some people that this has happened to, where an individual dies and the person was in a second marriage. Well, guess what? The life insurance was never updated. So that $1 million policy, that $1 million proceeds, is now going to the ex-spouse. And the current spouse has what? A goose egg. Nothing. Why? Because the beneficiary designations were not updated. Okay, so I hate to be that jarring on a Friday, but if it helps to get the message across, update your beneficiary designations. Mistake number 2, adding your kids to your bank account in order to avoid probate. Oh, Lord. I don't know how many times I've had people come to my office and say, Attorney Smith, I just figure I put my kids on my savings account, my checking account, just to save time and headaches so they can get access to the money. Well, a disadvantage to making your son or daughter a co-owner is that it opens the door to potential creditor claims that the child might have in the future. And if the child is going through a divorce, that account, the funds that are in that account, have to be declared on their financial statement. When you start a petition for a divorce, when you start divorce proceedings, that's one of the first things that you're required to submit is a financial statement where you list your assets. And guess what? The money in that account is considered an asset and they have to declare it. If that child gets sued, the assets in that account are now at risk. Okay, so this is what you're doing. Not to mention the fact that by naming that child a co-owner, they can go into your account tomorrow and wipe you out. And there's nothing that the bank would have done wrong because they're a co-owner. You've given them the power to do that. So here's a tip. How to avoid those nightmare scenarios from happening is, if you want to allow them to help you pay bills and that sort of thing, have a power of attorney done. The power of attorney, what it does is that you don't have to give control of your bank accounts. What you can do is have a durable power of attorney with the condition that it only takes effect when you are no longer able to manage your affairs. Otherwise, a power of attorney takes effect immediately. It is a very powerful document, so it is important that whoever you choose as your attorney in fact or your power of attorney is someone that you trust, right? But that is a solution around that nightmare scenario. If you want them to pay your bills and that sort of thing, you can just have a power of attorney done. And you can always revoke that power of attorney at any point. The power of attorney is only good while you're alive. Okay. Let's see. Mistake number 3: failure to make provisions for a problem child. Those of you who are watching know what I mean. After you're gone, your beneficiaries use their inheritance in a constructive way, or will they waste it? Past is prologue, so look at how they're managing their money today. That's going to be insight as to how they're going to manage money when you are no longer here. I had this issue come up with a former client. Will the funds that you set aside, in this case a will, as part of your overall estate planning strategy, will those funds be available for your children, for your grandchildren, or will they all be flittered away in just a few years? A solution for that problem, for that nightmare, is to set up a trust. And in that trust, you can name, well, every trust requires you to name a trustee who holds the funds for the benefit of, in this case, your children, until they reach a certain age. You can have instructions that funds are to be dispersed at different intervals. If you think that there's going to be a problem with kids blowing through the money that you set in, you designated for that trust account. And some of us have individuals, some have children in our family that may suffer from a drug or an alcohol issue. Nothing to be ashamed about, it just is. So if you want to make sure that you are providing for that child in that instance, a trust is a way of doing that, so that the child suffering from alcohol or whatever the addiction is has funds that they can live on, but the trustee has instructions to give those funds at certain periods, whether it's once a quarter, or however you designate, right? You've got someone that's managing those funds for the benefit of that child. And you can even say what age the child is to receive the balance of what's being held in trust. That way, if going back to that $1 million life insurance policy example I mentioned earlier, you don't have a child that just turns 18, gets a $1 million, windfall, and then suffers from drug and alcohol and flies down to Miami and just blows it all in one weekend. And now, they're living on the street. And I'm sure that's not the legacy that you want to leave. So my point in raising all that up is that there are tools to help you in almost every family situation, no matter how complicated or difficult it is. Remember, as long as the inheritance is being placed in a trust, it can be protected from the beneficiary's spending habits, from creditors, and even from divorcing spouses. Remember, I mentioned that before. Mistake number 4: trying to leave property to a minor child or a grandchild. Oh, Lord. I had this example come up during a meeting I had just the other day. First of all, no life insurance company is knowingly going to give away $1 million as life insurance proceeds to a 10-year-old. Okay? If you have not named a guardian for the child, if you don't have a will, a court is going to have to appoint a guardian. All that whole process, it takes money. Okay? And that person that's appointed by the court may not be the person of your choice, right? The guardian's job is to manage those funds until the child turns 18 and is legally an adult. Now, the problem is, the responsibility ends of this court-appointed guardian. So now this $1 million that's, sitting in trust, or maybe a little less than that if the guardian has had to use that, disperse those funds for whatever reason. But let's just work with that $1 million figure for a moment. How many 18-year-olds do you know that can responsibly manage $1 million in one fell swoop? I don't know. I don't know of too many. So the solution is, first of all, have a will, have a trust, and name the trust as a beneficiary on whatever life insurance you have that's going to fund the trust. And you can set specific instructions, and this is where working with an attorney is helpful. You can actually create a schedule as to how that money is to be dispersed, right? Mistake number 5, not doing an estate plan while your divorce is pending. Now, let's say that you have a will, right? But you're going through a divorce right now. What if you die before the divorce is final, right? In that case, I should say, your soon-to-be ex-spouse will inherit under your will or your trust if you have one set up. Therefore, it's important to change or amend your estate plan as soon as the divorce is filed. And remember, a divorce decree does not automatically change your beneficiary designations, such as a life insurance policy or like a qualified retirement plan. So you've got to file a change of beneficiary designation form with whatever company you're working with. All right. So let's see. Mistake number 6. We are almost done. Mistake number 6. Assuming your family will figure out who takes care of the kids and how. This is the throw it up in the air and see what happens scenario. What if both you and your spouse, if you're married, are in a tragic accident and you die? Don't assume that the family will somehow figure out who's going to take care of your kids. Have a will, right, that names a guardian, someone you trust, someone that is aligned with your values, right? I've assisted a number of individuals who have particular religious beliefs, and you want those traditions, those practices, to be carried on for your children to learn what they are. So you want to make sure that your guardian understands your wishes and is able to raise those children in your particular faith, if you happen to abide by a particular faith, or just is aligned by your values, right? As the kind of person the person that has the character and the qualities that you want to be modeled for your children as they grow. And the time to do that is when you are level-headed. You just take a good survey of the people that are in your life, and you sit down and say, okay, who do we as a couple think would be best suited to raise our children in the event the worst happened, right? And by the way, don't forget to actually talk to your prospective guardian, because this is a huge responsibility, and you want to make sure that they want to accept the role, and that they're able to, right? You don't want a family feud to erupt and your kids caught in the middle, which is what happened. You've seen it. All the nastiness that was tamped down and kept quiet while you were alive, all of a sudden comes to light now that you're gone, right? Both sides of the family are jockeying to see who's better suited to raise the children. Now, this is not the type of legacy that you want to leave for your children, right? The solution is make a will, and in that will, name a guardian. Make sure that in addition to that, you have a trust set up, and that with life insurance funding the trust, if you don't have funds set aside already in savings, place that money in a trust for the benefit of your children. So again, pick someone who is aligned with your values, talk to that person, have good communication with that person, and have everything set up so that that guardian is set up for success, right? To raise those kids. And then mistake number 7, the final one, is not having an estate plan at all. If you don't have an estate plan, most states are going to have one for you, right? And it may not be what you want. Dying without a will is called dying intestate. And I want you to go to elsawsmithlaw.com and then visit my blog page to read articles that talk about the risks of dying intestate. Now, not many people would knowingly let the state dictate what happens to their children, their money, and other assets after they die, but that's precisely what you're doing when you don't have a plan for yourself. So you've learned 7, there are more, but there's 7 estate planning mistakes that can block you from financial success. And you now know of plenty of free resources that are going to educate you on what estate planning is and how it can empower you. Again, visit my website, elsawsmithlaw.com, connect with me on YouTube, subscribe to my YouTube channel at Elsa W. Smith Law, and connect with me on all my social media platforms because I'm always putting free content out there. So there are many of you who are watching right now, and you know that this is an area where you fall short, right? You know you don't have it all together. You have nothing. You may have some, but not all the pieces that you need. But in any event, you're falling short. The great thing is that today, Friday, Financial Friday, you have an opportunity to change your legacy, to change that narrative going forward. So my question to you is, what are you going to do about it? Are you going to stay on the fence, or are you going to make a decision to change your life that can improve your life and that of your family? I want you to reach out to me. Again, I'm Elsa W. Smith. Call me at 410-995-7719. 410-995-7719, and let's get you scheduled for an estate planning strategy session. It's time to get your affairs in order. Do it for yourself and do it for those you love. Anyone who knows me knows that I'm really passionate about this because I've seen the transformation. I've seen the lives and the families that have been empowered after they've created an estate plan. So that's all I have for today, folks. It's been a real pleasure joining you today. Thank you to the What Now movement. It is Financial Friday. I'm your Maryland estate planning and business attorney, Elsa W. Smith. Thank you for joining me. Make it a fabulous rest of the day and even better weekend. I'll talk to you again soon. Take care.